Welcome everyone. Welcome to our fifth webinar this month in the celebration of Cybersecurity Awareness Month. So today we are going to talk about legal aspect of cybersecurity and areas where law and cybersecurity, intercepts and cross path. How individuals, private and public organizations are affected by it, and we'll talk about the Bill C-26 as well. So, in order to take the conversation forward, our today's guest is Dr. Argyri Panezi. Dr. Argyri is a Canadian Research Chair in Digital Information Law and Policy, an assistant professor at the at the UNB Faculty of Law, and affiliated member of Canadian Institute of Cybersecurity. At UNB Law, Dr. Panezi teaches courses on law and technology and cybersecurity policy. Dr. Panezi's research explores the effect that disruptive technology have on the citizens, institutions, and the law. At UNB, she establishes the Legal Innovation Laboratory, which is funded by Canada Researchers Program through her CRC Tier 2 grant, the New Brunswick Innovation Foundation, and the Canadian Bar Association Law for the Future grant. The laboratory is dedicated to the study of law, technology, and access to justice, focusing on Atlantic Canada region. I don't know about you guys, but I'm definitely looking to learn a lot about the legal aspect of cybersecurity. So at this point, I would welcome Dr. Argyri Panezi. Dr. Argyri, the platform is all yours, and welcome to the webinar.
Thank you, Sumit. Thank you for the introduction. Thank you very much for the kind invitation. I'm thrilled to be back and talk about the intersections of law and cybersecurity. As you mentioned, I will be talking about the infamous Bill C-26. I was invited to talk about this bill last year, and I had a great conversation with Dr. Windia from CIC. This time I want to talk about the landscape of the legal landscape at large, and give a little bit of an overview of which laws are applicable to the cyberspace generally and specifically in Canada. The answer is not as clear as we would have wanted, and that's I think what we're going to see together. So without further ado, let me start the presentation, and I will try to reserve some time for questions. If anyone has questions during the presentation, please feel free, and I'm right here to answer. Great. So if you can see the slides that I'm sharing, this presentation will focus on the points of intersection between these two fields, cybersecurity and the law. Do these fields intersect, and how? As a lawyer, I found that mapping cybersecurity laws, mapping the framework, the legal framework that is applicable to this technical field of cybersecurity is and has been and is still challenging. Why? Well, first because lawyers don't really came late into the game and don't really still understand what the field of cybersecurity covers. It's obviously a field that keeps expanding. Laws are trying to keep up with the needs of cybersecurity. Security threats are proliferating. Therefore, of course, it became, especially lately, a very important discussion among lawyers, policymakers. And then the immediate question was whether we have good, updated norms that are applicable in the various contexts where cybersecurity plays a role. And as lawyers, we usually intervene after an incident. We're not used to be proactive. It's mostly dealing with damages, dealing with the consequences of a breach. This is how lawyers come into the field. Of course, as you know better than me, the field needs more proactive regulation as well, which is something that the Canadian and other jurisdictions are grappling with at the moment. So mapping the cybersecurity laws is challenging because exactly it has not been done systematically and early on. Even defining the scope of cybersecurity laws is challenging because the approach of towards rules that these two fields have is different. There's this distinction between rules and standards. Lawyers understand rules as normative statements that basically state that if X happened, then this is the consequence. We don't really use standards. This is something that now we learn from cybersecurity experts. We are more comfortable with this distinction between principle and prescriptive rules that define the principles. This is the outcome that I want. I want, for example, a safe environment in commerce. These are the principles, and then industry or other actors need to comply with X principles. All the actions that the different stakeholders will engage in will need to be compliant with cybersecurity principles set by policymakers, by legislators. Or rules could be prescriptive. They could be hands-on, telling specific actors what to do. For example, if you are providing critical services, then you have to comply with 1, 2, 3, 5 requirements that are prescribed by the law. And then we will discuss liability if an actual incident and damages apply or arise in this case. And now even understanding this intersection and understanding what the relevant framework in each jurisdiction, including Canada, is equally challenging, because these laws are not found in one magic book of cybersecurity and the law. You have to understand which fields of law would be applicable, and then map the existing rules or rules in the making. And you're also at the same time trying to find rules that are international, domestic, or provincial, since we're talking about Canada. And this layering, these different levels make things even more complicated. A company might need to comply at the same time with national Canadian legislation, provincial legislation, for example, if they're incorporated here in New Brunswick, or even international legislation. Let's take the example of cybercrime, which you see listed here under the relevant sectors list. You might have international rules, for example, the Budapest Convention of combating cybercrime. You might have domestic rules, national criminal laws, and you might have also local rules on evidence with regard to what is applicable or what is admissible as evidence in a trial that deals with a cybercrime. This is a very rough list of the relevant legal sectors. One is obviously data protection and privacy. So if you want to map legislation laws that are applicable to the cybersecurity field, you definitely need to understand privacy and data protection frameworks. National security legislation, obviously, and as a subset, cybersecurity legislation. We do have national security laws in Canada. Cybersecurity laws are in the making. This is where C26 comes to play. And of course, lately, as AI becomes very, very relevant in cybersecurity, the question of AI regulation. Are there laws applicable to the use of artificial intelligence, the development and use of artificial intelligence specifically? Now, before I go into specific analysis of what are international laws applicable to cybersecurity and what are national laws, and I will only focus on specific areas, mostly data protection and AI regulation. before I do that, I do want to give an overview or a disclaimer of what do we mean by good legislation? How do lawyers evaluate the laws that we read? Good laws act as safeguards. They need to promote trust, including certainty and accountability vis-a-vis the law. We apply these principles that we call the rule of law. This is quite important to remember because especially when we're regulating different technologies, you do want certain flexibility. You do want adaptable laws that can keep up with the needs of the time, the progress of this technology and the new needs. However, the legal system is by design slow in order to promote certainty, which leads to trust. You cannot amend laws very quickly. There's a reason for that. We don't want citizens to be uncertain as to which laws apply. They need to be involved. We have a democratic sort of accountable process in introducing new rules or amending older rules. And this kind of backward looking, very slow process that the legal system is used to is definitely not as intuitive in the world of technologists, security experts that have to be adaptable. They have to be quick in their decisions. So there's a tension here. Good laws needs to be simple so that they're understood, but they also need to be sophisticated so that they're not leaving significant gaps. They're not creating significant gaps. And again, this is another tension to write rules that are at the same time simple, understood, and sophisticated. Alongside flexibility comes also this notion of tech neutrality, which I think is important for this crowd. In theory, we need to be writing rules and legal norms that are technology neutral so that they can be adaptable and applicable to many contexts and not have significant gaps. However, the legal system, even if there are gaps in the legal framework, the system itself will try to fill in the gaps. How? Applying rules of interpretation. If a judge has a case before them, they will find a way to apply rules and principles, even if the bill that they have in front of them and they have to apply is not as clear or has gaps. This is the common law approach, which is basically a safety net to avoid over or under regulation. And now, unless I have a question, I just wanted to check. There was, I think, a question in the chat. Oh, great. I wanted to talk in a little bit more detail about the two big sort of groups of sources of law in the international sphere and the domestic sphere. So when we're talking about international law, the sources of law, where we find laws, are in international conventions, that is international agreements between states, and in international customs. This is a little bit more technical or idiosyncratic. What are customs? What is an international custom? There needs to be evidence that there's general practice by states and that this general practice is accepted by law, is accepted as law. In addition to these core sources of international law, international agreements, agreements between states, and customary rules, which require general practice accepted as law. So many states in practice follow these norms and they think they are legal norms. In addition to these two, we also have general principles of law guiding international judges. We have judicial decisions and teachings of the most qualified publicists also guiding judges. But the most authoritative would be the first two. These are all found in Article 38 of the Statute of the International Court of Justice. Now, This is a tricky area because, as you can imagine, it was not straightforward that international law applies to the cyberspace. This is the question that I pose here at the end of the slide. It is still an open question whether international law is applicable to the cyberspace. There's no international convention, there's no written agreement between states stating that. There's a customary rule that is being developed with more and more states stating that yes, international law is applicable to the cyberspace. Canada is one of these states. Canada has declared officially that according to the Canadian government, international law is applicable to the cyberspace. This means that this is not only an important statement for international law since it creates custom, it is also an important statement for Canada because Canada then needs to abide by its own statement, needs to follow its own statement. If Canada states and accepts that international law is applicable to the cyberspace, then as a country, Canada needs to operate in the international arena, applying international law rules and respecting international law norms, while thinking that they're equally applicable in the physical space and the cyberspace. It's an interesting area because the early questions of internet laws really were about jurisdiction. Technology defies borders, and then you had this technology defies borders. This was by definition, and then you have laws. You have attempts of legislators to also defy borders, to apply rules extraterritorially. These are in the early days, the 90s and 2000s, when questions of jurisdiction were still very open. We've moved towards an era of international cooperation when it comes to applying rules on the cyberspace, especially in the space of cybercriminality. There is international cooperation to combat cybercrime, and there are also all these efforts in the international field have also translated into reforms in criminal, domestic criminal legal frameworks, including the framework of the Canadian domestic framework. At the same time, in the international level, we're protecting the internet backbone. What do I mean by that? There are rules, for example, applicable to the protection of undersea cables. You can think about security threats around the internet backbone, mostly physical threats. The United Nations Convention of the Law of the Sea, that's the acronym that you see on your slides here, UNCLOS, is applicable to the internet backbone, to the undersea cables. Arguably also the ITU Constitution, the Constitution of the International Telecommunications Union, that's an international organization under the umbrella of the UN, the United Nations. Last but not least, and especially relevant today when we have multiple hot war zones around the globe, cyber operations. If we think that international law is applicable to the cyberspace, obviously international humanitarian law is also applicable. And then there's a whole framework of laws that are applicable to hostile cyber operations, either in the context of a hot war that's used at bellum, or in the context of humanitarian, international humanitarian law, and that's used in bellum. And not to forget the economic and security nexus. Obviously, critical infrastructures that are protected by these international norms are dependent on the supply chain. Think about raw material, tech supplies, also the movement of talent. Therefore, trade laws, but also labor laws that I forgot to add here on the slide, are applicable. More indirectly, I would say rather indirectly. Now, the second large category would be national laws applicable to cybersecurity. We mentioned Bill C-26 and had an extensive discussion last time around this bill. This is a proposed bill. You will see in the next slide that it's currently in under consideration in its third reading before the House of Commons. After that, oh, I'm sorry, this is an old slide. At the moment, we are not there. There is some progress. So we are in the second reading at the Senate. So, oh, yeah, so this is a little bit older. The House of Commons, we have the first, second, and third reading in the House of Commons are already completed, and then we are before the Senate, going towards the third reading. So it is likely that the bill passes soon. Now, the purpose of this bill is to protect cyber systems in order to support continuity and security of vital services. And this notion of vital service is important because it explains the scope of the legislation. Let's take a look at the definition of what are vital services, vital systems. The Schedule 1 of this bill lists 6 sectors as vital. Number 1, telecommunication services. 2, the interprovincial and international pipeline and power line systems, nuclear energy systems, transportation systems, banking and clearing and settlement systems. Now, as I said earlier, the bill aims at supporting the continuity and security of these vital services, which means that when there are risks in respect to the critical cyber systems, they need to be identified, managed, and then the systems need to be protected from not being compromised. If there are incidents, they need to be detected and managed, which means that the impacts of the incidents needs to be minimized. As you see in the statement of purpose of the bill, the supply chain and the role of third-party products and services is also mentioned. I will stop here as regards Bill C-26 so that I go through the next 2 sectors, privacy, data protection, and AI. But I'm sure that there are more questions, especially around Bill C-26, which is projected to be the most relevant piece of legislation that is coming here in Canada for all cybersecurity experts. And we can talk more about this after the presentation or after I go through my slides. Area number 2, data protection. I would say that this is a prerequisite to all other legal norms that are applicable to cybersecurity. Even the Bill C-26, you cannot talk about security at large of the system before having defined security of the data. There are 2 layers of data protection in Canada. One at the federal level. One is the act applicable to industry, PIPEDA, the Personal Protection and Electronic Documents Act. And then there's the act that is applicable to government institutions, the Privacy Act. What's the difference between the 2? One is defining the obligations of private actors when they are collecting and using personal data and making available personal data. The other one defines obligations of government institutions in their collection, use, making available of personal data. For example, when the government issues an ID, the Privacy Act is applicable. If we think about an electronic ID later on, again, the Privacy Act is applicable. When you have a private company offering services, when you have a bank, for example, giving you access to an online platform to monitor your account, then PIPEDA and other more specialized rules would be applicable. It's this is a very important part of the legal framework when we talk about cybersecurity. However, I would say that this is probably the biggest pain point in terms of the Canadian jurisdiction. Two pieces of legislation that are quite outdated. There are ongoing efforts to update, to reform these rules, including the proposed Bill C-27, which is the Artificial Intelligence and Data Act. We're going to talk more about that as I'm moving towards the third part of the analysis, the rules that are applicable to artificial intelligence. There are a number of reasons that contribute to delays in these reform efforts. Bottom line, we do have rules applicable to the protection of in the area of personal data protection. They're quite outdated, and this is becoming a significant issue and challenge for Canada. And moving to the third sector of regulation, that would be AI regulation. As a matter of general frameworks, we have two basic approaches to regulating AI in the legal sphere: risk-based approaches and rights-based approaches. The risk-based approaches seem to be dominant, so you have rules that are focusing on regulating different types of risk. The most common example is the the European Union's AI Act, which I will show on your screens in a second. We have both national and global efforts to regulate AI, and we have a general difficulty in defining AI, which then spills over to these efforts. In Canada, the relevant discussion is again before the Parliament. We have Bill C-27 that I mentioned earlier, since it touches the reform on the Data Protection Act. The bill is offering a definition, includes, these are proposed provisions. They're not good law yet. They suggest making an offense, for example, to utilize AI systems in order to and cause substantial economic loss to individuals, etc., and suggest fees and damages so that they deter actors from engaging in such practices. This is the relevant punishment, for example, that is proposed. So you see these fines, heavy fines imposed, or the suggestion of the proposed bill imposed to individuals that would risk, or that would place citizens in risk. The EU approach is a little bit more robust. We have an actual passed AI Act, so a bill that has become not a proposal, but an actual act that is in place at the moment, is enforceable. And these 4 levels of risk are the guiding approach. The AI Act has carved out a few applications of AI as prohibited, and these are applications that introduce unacceptable for the legislator risk. And then you have the division, the 3-layer division: high risk, limited risk, and minimal risk. Obviously, high risk users and the high risk category of AI systems will be subject to more strict compliance requirements, less strict compliance requirements for limited risk and for minimal risk applications. I will go through the rest of the slides very quickly so that I come back to the discussion. I just wanted to say that there are global efforts to regulate AI. The Council of Europe, for example, is taking a rights approach. Obviously, this is a human rights organization. And very recently, you see here, the date is May 2024. The Council of Europe celebrated the first international treaty on artificial intelligence. And as I said, this treaty includes or lists certain rights that need to be respected when it comes to the use and deployment of AI. Reminds parties that human rights need to be protected, the democratic process and respect of rule of law are paramount, and includes certain rules that are applicable, which I can go through in more detail if there are questions. The UN is also trying to adopt resolutions. These are more like recommendations rather than rules, but also relevant in the legal space. And last but not least, the US approach, which is a very different approach to either the European risk-based approach or the international rights-based approach, which is the standards approach. And this might be the approach that cybersecurity experts are more familiar with, because it really stems from NIST, which I know is a framework that you're all very familiar with. And again, for the interest of giving some time to the discussion, I will scroll through these slides and give more details if you want to focus on the US framework more. And I will stop there and come back to the group and to Sumit. So I see a question here, two questions here by friends from the CIC. So we have Kostadin Pasaris and Farouk Aner. Should I read the questions? Sumit, do you want to facilitate as you wish?
I can do that, Dr. Panezi. So our first question is from Constantine, and the question is that with respect to legislation, policy, and guidelines, are we moving as quickly as developments and innovation in cybersecurity and AI?
Absolutely not. The answer would be absolutely not until very recently. There is a momentum. So you do see that legislators are alert. There are ongoing efforts, but we started late. And this is a usual thing when it comes to regulating technologies, which really is obvious at the moment. I would say, and that's a very, very interesting comment, an interesting remark for the purpose of this discussion, because the most important thing is to see how these two worlds intersect and why is there this challenging reality where you have security experts needing to respond to new threats and basically practically diving into the new issues, and then you have lawyers and policymakers seen as being very slow. I will again say that this slow approach and cautious approach is really built into the legal system. So it's not necessarily a bug. It is a feature that we need to be cognizant of, but also critical. We still need to remain critical when it comes to facing actual needs at the moment. What I mean by that, we don't have to rush and introduce long or not really sophisticated rules that will make the lives of everyone, including cybersecurity experts, difficult in the future. The legal system has the ability to operate in a vacuum, has the ability to fill in gaps when cases reach courts. That's not necessarily the best way, in the sense that you do expect that there's a legal framework that is there, robust, you can read it, you can understand it, and then you know what kind of obligations, for example, you have as a company or as a individual. Of course, this is the ideal scenario, but we don't easily we're not easily there immediately, especially when there are new types of threats that are coming about. Think about generative AI that has changed the game for cybersecurity experts and for lawyers. Our own profession is being attacked because we work with language. So you can imagine that large language models are threatening to our own existence. And you will have very conservative views if you think about if you ask regulators to very quickly think about legislating, the intuitive reaction, for example, of the Italian data protection agency back when OpenAI initially released ChatGPT, they banned the service. You do have these very conservative immediate reactions from lawyers because that's how we think. Whatever is threatening, we need to stop and wait. We're not there to deal with threats, right? That doesn't come as an intuition to us. That's why I think that the collaboration between these two fields is key, and is actually might actually lead to a golden standard, because you do need to have a forward-looking and to have a technical to have individuals with technical expertise in order to engage in practices that are result in immediate effects. On the other hand, you do have to have the slow and thinking legal system to analyze these immediate practices, and then to think about principles that should apply. What is the legal outcome that we want to achieve? And then codify. Codification is key, but codification is slow, and this is not only a problem, it's also not only a bug, it's also a feature.
Thank you, Dr. Panezi. I mean, certainly insightful, and you covered all aspect of the question in a fairly extensive sort of way. With this, we'll move to the second question. So our webinar joiner, I mean, Mr. Farouk Inner, so he asked, with the introduction of Bill C-27 replacing PIPEDA, how do you see these changes aligning Canada's privacy framework with global standards like the GDPR? Could a stronger role from the provincial legislation complement these updates to address unique regional challenges, especially here in Atlantic Canada, and foster a more cohesive national approach?
So this is an excellent question and really on point on IDA, on this, again, suggested rules, the Bill C-27. These are not laws that are enforceable at the moment. These are amendment proposals. C-27, unlike C-26, will likely not pass before a change of government. So that's also quite unfortunate, especially when you compare it with the GDPR that Farouk rightly compared it with. You have the General Data Protection Regulation from 2018 or 16, if I'm not mistaken, in the EU, the golden standard of privacy of data protection regulation. You do have this so-called Brussels effect. Once the GDPR was in place, this quickly became the global standard, similar to the NIST framework as a global cybersecurity, as an emerged global cybersecurity standard. So yeah, there Canada was slow, but it was not just Canada. Most other countries were slow, and the EU is notoriously fast in regulating. If the EU knows does something well, that's regulating, and sometimes over-regulating. So we do have this set of rules introduced by the European Union. You do have global players at the moment familiar with this kind of standard, which means that the standard of data protection regulation globally is already higher than what you see in Canada. The picture in Canada is a bit grim at the federal level, or gray, but it's different at the provincial levels. And you do have certain provinces, notably Quebec, introducing much more robust and detailed data protection laws and requirements. Now, when you think about what is best for each province, obviously, this is not only a challenge, it's an opportunity. You do have the decentralized mode of governance in Canada, which can actually be to the benefit of industry and citizens. When you think about promoting investment in data industries and new technologies, obviously a province like New Brunswick can take the lead and think about its own standards, which could be higher than either the current or the anticipated federal requirements. And what we have seen, generally speaking, is that certainty and detailed requirements that actually do not surprise industry are benefiting innovation, are promoting innovation. Not to the extent, we don't need to go to the other to the other extreme. It is a current discussion in the EU whether all this very stringent web of legislation and regulation has been actually promoting or hindering innovation, but we're nowhere near that in Canada. In Canada, and particularly with respect to data protection, we do have our starting point is very different. I want to give one example at the federal level, which I think is relevant to the cybersecurity experts here. The way in which the Office of the Privacy Commissioner dealt with complaints post Cambridge Analytica scandal. I imagine that the Cambridge Analytica scandal is a familiar case in this audience, so I don't need to go into details on that. So what happened is in a number of jurisdictions, the different agencies had to deal with complaints, citizens' complaints. A number of Canadians that were actually affected went to the, or actually a minister in this case, but individuals could go to the Office of the Privacy Commissioner and make complaints against the party that they thought harmed their privacy. So there have been complaints against Facebook, and the Privacy Commissioner issued a decision and said, yes, Facebook actually breached the rules of PIPEDA, breached the privacy rules, did not protect, did not safeguard individuals' data enough in the case of the Cambridge Analytica saga. This then was appealed by Facebook before the federal court, the trial court, and the trial court actually agreed with Facebook and said, no, the breach was by a third party. That would be the app provider that had a contractual relationship with Facebook. Therefore, and also said that the Privacy Commission did not bring enough evidence forward to demonstrate that Facebook has infringed rules, any privacy rules. This was the decision in 2023, last year. This year, 2024, the federal court now of appeal reverses the decision and says, no, absolutely, Facebook has breached its obligations vis-a-vis the consumers, because in their third parties had access not only to data of individuals that had consented to it, whether it was meaningful consent or not is a huge question, but also friends of the contacts of these particular individuals, where the data of third parties, contacts of individuals that had immediately agreed to the terms and conditions of the application and downloaded the application, were also accessed without authorization. Therefore, there was an actual privacy breach. So you do see that the common law system is ready to deal with cases brought before the courts. When the legislation is not robust, you do have this very surprising effect. It was interesting and rather surprising that you have the trial court siding with Facebook 100%, and then the federal court the next year siding with the Privacy Commissioner again 100%. You had two very, very different decisions there, and that's kind of that's where these are the consequences of not having a very robust legislative framework in data protection, which then might confuse, might also lead to confusing case law. The direction is a good one, though. When you see the Court of Appeal, you understand that, okay, you had a confused trial decision, then this was fixed later.
Thank you, Dr. Panezi, and it's good to see that I mean, at least here in Canada, we are holding these large corporations to their responsibility, and I mean, in a certain way, the law, the law and the legal, the legal aspect of it is moving in the right direction. So we have a couple of more questions before we come to the end of the webinar. So the next question is, this is with respect to the privacy and security. In the light of recent I mean, cybersecurity threats, how does Canada's legal framework balance individual privacy rights and the national security concerns? Are there specific legal areas where you see two of them conflicting with each other?
Yeah, very, very good questions. Yeah, absolutely. Bill C-26, we're back in the obligations of critical vital services operators, and there you do have an obvious conflict between protecting security and individual rights. What the proposed bill suggests is that it includes rules that would be applicable, a sort of emergency rules framework when an incident that could likely affect critical services, a number of huge number of Canadians comes to play. Then the minister or individual or members that the minister would appoint, depending on which sector we are, the relevant responsible minister has powers that are very broad to introduce orders immediately effective. That could be. It's really an open-ended list. If you read the Bill C-26, you will see that the minister in such instances has the power to order anything that they see important, and this could include, for example, making secret orders as to somebody's access to the network. These are all open-ended and very broad provisions that have created that have made privacy experts and human rights experts very uncomfortable thinking about charter rights, thinking about privacy rights, thinking about due process. I would say that the concerns that have been voiced around these particular emergency rules that are included in Bill C-26 are valid, and they're being discussed. Hopefully, this will not be a difficult discussion. I can see ways forward. There are institutions like the Canadian Civil Liberties Association and other partners that have suggested ways to amend the rules so that they're a little bit more protective. They include transparency requirements, accountability requirements, etc., so that we quote unquote save the bill, which might be important. Otherwise, we'll end up in the same situation as we are now with the data protection rules, where the reforms are not coming anytime soon. It might be more relevant to introduce the bill, hopefully an amended and improved version of these provisions, so that this would and actually find a better balance than what has been found already in the text of this bill. Yeah, very good, very, very sophisticated questions, right on point when it comes to the debates, the current debates around the bill.
Yeah. I certainly see a lot of interesting question popping out. So before we come to the end of the webinar, we'll address one more question, and this is with respect to, collaboration and standards.
Mm.
So as we know, cybersecurity is a global issue. So how does Canada's legislative approach to cybersecurity compare to international standard, and what role does international collaboration play in shaping our laws? I see that you address the EU and the US part of it. So certain part of this question might be addressed in your presentation, but I would like you to address
Yeah,
them.
no, absolutely. It's a good question to wrap the discussion, because I can touch on the international law norms and then the standards. How does Canada participate in standards development? So Canada has been leading the discussion when it comes to applicability of international law on the cyberspace. So there we have, a very important role. Canada has an important role to play. It's an important power, and can also be we've also seen Canada acting as a mediator when it comes to very heated debates in the international arena. Now, when it comes to cybersecurity standards, for example, the contribution to NIST frameworks, etc., you do see that Canada follows the trend makers, if for lack of a better term, or the bodies that have already dominated in this space. So you do have the NIST framework, which is an American framework, being dominant and remaining dominant. But from what I understand, also listening to the way in which Canadian agencies, so for example, the Canadian Center for Cybersecurity, we have Canadian experts collaborating within these institutions in order to set new standards, update existing standards, etc. So in that sense, obviously Canada collaborates with allies, right? Because when we're in the international sphere, you do have geopolitical tensions that play a big role in which side who are your allies and who are the players that you collaborate with. And you will find it much more difficult to talk about collaboration really at a global scale, because you do have these geopolitical tensions. One thing that I didn't mention, and it links to all the discussions here, is this race to achieve technological sovereignty. This is an interesting space. One goal that all stakeholders have is to keep citizens safe. At the same time, they want to keep their citizens safe. You do have discussions around global threats and threats to democracy, and the deployment of AI tools to penetrate systems that are directly linked to the democratic processes, for example, manipulate voters, etc. And there's a tension between collaboration and just closing into your own borders and hoping to provide your citizens with the most secure structures. And that's a real tension, right? It's a real tension because the technology itself, as we said, defies borders, and then legislators and policymakers are still elected, obviously, by government, by specific by citizens of different nations, and they're accountable to these citizens who they need to keep safe.
Thank you, Dr. Argyri. That was really an insightful session, and I liked how you covered the law, the law and the legal aspect, not just in Canada but across, United States of America and Europe as well. So the key takeaways, this is like a work in progress. While we have achieved a lot, we have gone in the positive direction, but there are certain things which are still, left to be done. And again, thanks to you for, joining the webinar, and to others who joined and added value by asking those insightful questions. So with this, we come to the end of the webinar. So thank you everybody who joined us today. So goodbye for now. Thank you and have a good day.
Thank you. Thanks so much.
Thanks.